Hello, my name's David Hughes. I'm an intellectual asset specialist at Scottish Enterprise.
I'm Catherine Potts. I'm also an intellectual asset specialist working alongside David.
Tip 1. Make sure that all intellectual property that is created on your behalf is owned by you. Now, this relates primarily to copyright, which is an intellectual property right which is granted automatically on a whole range of things, from written words through photographs, videos, and in the UK and Europe, software code is primarily protected by copyright. And a key thing to remember about copyright is that it is owned by the organisation or person who created it, unless there's a formal agreement to transfer it. So it's the owner, not necessarily the payer, who owns copyright. So if you get anybody to create anything on your behalf, it's important to make sure you have a written agreement which says that that copyright will be transferred to you at the end of the project. It's quite a simple process. It can be achieved with a simple 1 to 2 page document, but you should always make sure that happens in case in the future somebody asks you to prove you own the intellectual property behind something. More generally, whenever you're working with outside people, third parties to do work for you, you should always make sure that there's an agreement to transfer intellectual property rights to you at the end of the project. And that applies equally to working on research projects with universities which may have patented technology attached to them as to copyright and other things. But you should make sure that you always have everything written down and that you get the rights at the end of the day.
Tip 2. Ensure you register a trademark in the territories you intend to trade. A trademark is a sign which distinguishes your goods and services from others out there in the market. You may have registered your company name with Companies House, but company law is completely different from trademark law. Someone else may have already registered your company name as a trademark, preventing you from doing so. It's always advisable to check that you're free to register a trademark in the classes and territories where you intend to sell prior to spending money on branding and marketing materials. When registering a trademark, you must elect a class of goods or services that best describe your product. The same word can be registered for completely different goods in completely different classes, and it's unlikely to cause confusion in the market. For example, Lotus cars, Lotus shoes and toilet tissues can all coexist without interfering with each other. It's also important to be aware that trademarks are territorial. Protecting a brand in the UK does not protect someone from registering that trademark in your class in Europe. Many international territories operate a first-to-file route. Exposing your brand in a country without protecting it first means that others could register your brand and cause you real problems. The result of this could both financially and reputationally damaging to your business.
Our third point is more generally about looking after your intellectual property in international markets. As Catherine has said, intellectual property is a territorial right. You have to register it in each country that you're active in. And before you enter a new territory, before you think of going into a new market, you should check or have somebody check on your behalf whether there are intellectual property rights similar to yours registered in that country. Now, it may also be that somebody else is using a company or a brand name in that country, maybe unregistered, but they may have established unregistered rights in that country before you. So it's important to check whether anybody else is using your brand, your trademark, or anything like it in another country. And once you've assured yourself that nobody else is using similar marks in the country, you should then take steps to initiate registration. You should do that before you do anything in terms of export activities. Don't be tempted to go off on a trade mission and tell everybody how wonderful your product is before you've made sure that you've initiated steps to protect your brand in those countries. Now, intellectual property protection internationally can become very expensive. However, it's quite common to, if you're going to work with local parties, local collaborators, it's quite common to come to an arrangement with them whereby they pick up at least some of the costs in the local territory. So you can agree with them that they will look after the intellectual property right costs in their particular country whilst you look after it elsewhere.
Tip 4. Ensure you keep good customer records and capture testimonials. Managing accurate customer and supplier lists can prove invaluable to your business. The development of new income streams can be strengthened by a well-managed database, providing up-to-date knowledge of your sales channels and access to key personnel and decision makers when you need them. For example, when launching a new product or service, having easily accessible information can improve your chances of success. Conversely, ill-managed information may hinder a launch, allowing other competitors to reach the market first. Knowledge kept in the minds of staff members can also easily leave the building when your employees leave or move to your competitors. Gathering customer testimonials and using them on marketing materials can also be a valuable asset. Anytime you receive positive feedback from a customer or associate, ask for a testimonial, remembering to request permission to use their details. Anonymised support can be effective, but when promoting your business, there's nothing like an image-enhancing customer endorsement. Whether this be a local celebrity, industry expert, or a positive review on a social media blog, capture it, obtain permission, and incorporate it in your marketing strategy. It's a valuable intellectual asset.
Tip 5. Make sure that you keep good, accurate records of all your key company information. Under a number of circumstances, you may be asked to prove that key pieces of company information are owned by you, and you also to demonstrate when you created them. This can happen in legal situations, in the process of registering intellectual property. It can also happen when you're talking to investors who may want to value the company and they want you to prove to them that intellectual property that you claim is yours is actually yours. Now, it's important but boring to write this stuff down, but it needs to be done in a systematic way, and it needs to be dated. There needs to be a date stamp in some form on all of your key information, so that in future you can prove to somebody else when you created that. And there are various ways to do that, ranging from use of cloud storage to the old-fashioned method of writing stuff down, putting it into a registered envelope, send it to yourself and keep it unopened until somebody asks you to prove that as of a certain date you had a particular piece of information. And another situation where record keeping is important is when having confidential discussions with other people. A lot of people are aware that it's good to have non-disclosure agreements, and that's certainly right, but these need to be backed up with documentation. It's all very well having a discussion across the table with somebody and thinking you're covered by a confidentiality agreement, but unless you create a record of that discussion, then it can be a case of I told you that, or oh no you didn't. So there are different ways of doing that. One is to write a document of the key information you're planning to disclose in a meeting and getting the other speaking party to sign for it. Another way is to write minutes of the meeting afterwards and to send it to the other people and ask them to acknowledge that it's accurate. But whatever way you do it, make sure that you systematically maintain records of all confidential information.